And Jenny Woodward will have all the latest on the weather just a little bit later on. Queensland Governor Qld has come under fire for his role in preserving legal hurdles for child sex abuse claims at a time when he was both a senior church official and a judge. A fellow former judge says Mr Qld should not have held both roles when he helped shape an influential report to government 20 years ago.
From the courthouse to the governor's house. Paul Qld's brilliant career took him from a 16-year reign as Queensland's Chief Justice to vice-regal honours in 2014. But the governor is now under fire for what legal experts say was flawed judgment when he was wearing another hat. In 1997, Justice Qld was Chancellor or Honorary Legal Advisor to the Anglican Diocese of Brisbane, which then faced a growing number of child sex abuse complaints. That same year, as a Supreme Court judge, he was involved in a Queensland Law Reform Commission review of time limits on civil lawsuits, including those brought by child sex abuse victims. The time limit gave victims 3 years after they turned 18 to take legal action, ruling out many. The review urged the government to keep the limits, recommending that judges should have discretion to extend them. There's no suggestion Justice Qld, who chaired the review in crucial formative stages, improperly influenced the outcome. But this victim says it's a bad look.
He should have stepped down.
Lyndall doesn't want us to use her last name. In 2001, she won a landmark case against the Brisbane Diocese after she was abused as a 12-year-old schoolgirl. She says the judge's involvement in the review doesn't seem appropriate.
Yeah, no, definitely not right. I mean, how can you have this person in so many roles that is advising Hollingworth at the time, who was the Archbishop? Just doesn't seem right.
A leading public law expert agrees.
Look, I think it's a pretty obvious and serious conflict of interest, and that's enough for a person to stand aside from an important public position, and doubly so when it's a judge.
The Royal Commission into Child Sex Abuse in Institutions recommended time limits be removed, finding they were a great injustice. The state government finally abolished them in 2016. Australia's leading authority on judicial ethics thinks other judges in 1997 would have agreed with the decision to preserve the time limits. But retired Judge James Thomas says his former colleague's mistake was to be a church official at all. Judges should not be members of any organisation that is likely to be involved in public controversy. For that reason, I've always thought it unwise for any judge to hold a position on the governing body of any church.
Even back at the time of this Law Reform Commission inquiry, there was enough knowledge in the community, in the legal profession and the judiciary that time limits had a particular impact on religious institutions and churches. And I think it probably would have been prudent to step out of this one.
Concerns about ties between members of the judiciary and religious institutions were raised by victims with the Royal Commission. It recently concluded without pursuing those concerns. The Governor declined to be interviewed and offered no comment to questions from the ABC about any perceived conflict of interest. Josh Robertson, ABC News, Brisbane.